Have you ever stopped and thought, if something happened to me tonight, would my family actually know what I own and how to protect it? Listen, I talk to investors all the time who have rentals, one LLC, a business in another LLC, brokerage accounts in their own name, and a bunch of life insurance and retirement accounts, and no one in the family has the full map. Well, in this video, I'm going to show you how the wealthy fix that with one structure, and it's called a family holding company. So when it's done right, you get better asset protection, cleaner tax planning, and a roadmap your family can follow when something happens to you. All right, let's get started. Okay, so why am I walking you through this? Well, it's because it's what I see sophisticated families do, and it's what we do here at Anderson to help people protect themselves. So they move from a bunch of scattered assets and LLCs and personal ownership in different entities into one complete entire whole picture. And we do this through a family holding company, which in plain English, it's like an LLC, right? It's a limited liability company or a limited partnership. And it's what will actually not only consolidate your assets, as you're about to find out, but it also protects your family from creditors, divorces, and bad decisions your kids may make going forwards. Now, in trying to determine whether or not you're using a LLC or a limited partnership or possibly even a corporation, I'm going to get into that. And how the tax rules work and how you can plug all your assets into this one structure so you can pass it on in a controlled way. And along the way, I'm going to give you a story about a family that didn't plan and one that did, so you can see the, this versus that real life scenario. Okay, so let's start with the definition of a family holding company, right? It's simply a legal entity that doesn't run the day-to-day business. Its job is just to own stuff that does run the businesses. So think of it as a parent, right, on a family tree of entities. The parent owns all the various property LLCs, maybe your operating company if you have your own business. It could possibly even own a brokerage LLC or private notes that you may have. And that all these little separate LLCs that are owned by the parent, they're the ones that are actually doing the things. They're the ones collecting the rents, dealing with the tenants, holding the brokerage accounts, signing contracts, selling stuff out of the actual business, hiring employees. But it's not the family holding company, right? The family holding company, as I stated, it's just the owner of stuff. So let me just show you right here what I'm talking about. So we have this holding company right down here. And as I stated, it could be owning all these other various companies. So maybe this is real estate right here. Maybe you've got an active business over here. So this is my business LLC. And they're all held down here like this in this one company. Now, the question is, what type of structure should this family holding company be? I've watched a lot of videos on YouTube. People are talking about this, touching on this, having a family holding business set up. And they'll typically talk about either a corporation. I've heard some people talk about limited partnerships, and a lot of people talk about limited liability companies. Now, it's important that you understand the distinction between these if you're going to set up the structure, because a wrong move can have serious tax ramifications for you and limit your overall asset protection. So we want to make sure that we're putting something in place that is not only going to protect us legally, but it's also not going to increase a tax liability into the future, and at the same time, protect you from a control standpoint. So let me start off with the first one, corporation. Right, I'm just going to tell you this. When it comes to creating this family holding company, you do not want to have a corporation there. There's very few possible situations where a family holding company should be set up as a corporation, either S or C. And the reason why has to do with taxes. That is, when you set up an entity, an S or a C corporation, it's going to limit your ability to deal with assets, meaning pulling them out and putting things back in without there being potential tax ramifications. And so if we're going to set up this structure that's going to own all of my stuff, I don't want to be tying my hands in any way that's going to limit my access to these assets in the future without Uncle Sam slapping me on the hand and saying, hey, you got to pay me some money. So I typically will never look at a corporation as being this entity here. And so that leaves us with two other types of entities. Number one, it's the LLC or the limited partnership. Now, both of these entities, a limited liability company or a limited partnership, they're both what we refer to as flow-through entities. Now, you like that term flow-through when you're talking about a family holding company, because what it means is that any income that passes from this entity to this entity flows down to you. Now, in Gaining that flow through treatment, you also get the benefit that you can move assets in and out of these entities without there being any negative tax ramifications. So for example, if I wanted to take this property right here in this LLC and pull it out and maybe move it somewhere else, I could do that and I wouldn't have a tax ramification for it. Whereas if it was a C or an S corporation, family holding company, I definitely would. So that's the main benefit. The second reason why we like this type of structure, okay, is for asset protection. So if you've looked at some of my other videos, you know I talk about the charging order protections and how important that is from a legal standpoint, meaning that if I'm the member of this business right here, this family holding company, and somebody were to sue me, they would not be able to take this company, which would then give them access to all of these assets. Okay, the charging order, what it does for you, okay, let me just spell it out here if you're not familiar with it, charging order protection. Okay, so what it does for us is it limits a creditor's remedy to whatever I receive from my company, any distributions I take out, or maybe your future beneficiaries when they become members in your LLC, like your children. So in basic terms is they can't take your LLC from you. They can't force you to take money out of your LLC. They just sit there and wait and hope, pray that you'll distribute some money to yourself, because if you do, then they get paid. But we know that we're never going to do that. We're not going to take money out of it. It means it has to go to our creditor. So this gives you better bargaining power in trying to negotiate a potential judgment away and get that creditor to settle for your policy limits. So I like it from that standpoint right there, from the asset protection side. Now, the other benefit about having these types of structures, okay, especially the limited partnership, is that with the limited partnership, you can take advantage of what is called discount valuations. All right, so the LLC came along after the limited partnership in this country. That is, the limited partnerships have been operating for over 100 years as a business structure. And then in about 1970, so Wyoming adopted the first limited liability company statute. Now, the limited partnership had been noted, and still is to some extent, for its ability to take assets and reduce their value for estate tax purposes. Now, if you're wondering, what the heck is Clint talking about? Let me show you. You see, when you set up a limited partnership, the way it works is you have, here's your limited partnership, we'll just call this LP, right here. You have your limited partners, which is typically going to be mom and dad, right down here. Okay, these are what we call limited partners. Now, the limited partners do not actually control the limited partnership. They are there, they get to receive whatever the partnership distributes to them, but they have no control over what's going on inside of here. The control rests with the general partner. Okay, we call them the GP. Now, in a limited partnership context, we're typically going to structure this with a general partner that is not mom and dad, although you could do that if you wanted to, as long as this doesn't hold any dangerous assets. But generally speaking, we'll oftentimes use a LLC, a disregarded LLC up here, as the GP of our limited partnership. And again, this is owned by mom and dad. So all the decision making is, we'll call this decision entity right here. So the decision entity determines how this company is run, meaning if any money is going to be distributed. Or I'll give you a perfect example. Let's assume that I have some property LLCs here that are owned by this limited partnership. And we need money up here to do some CapEx on this property. Well, we've got cash sitting here. That decision to move money from here into this entity is going to be made by the general partner. The general partner makes that decision. So these individuals right down here, even though they may own 99% of this company, they have zero control over the company. Now, why is this an important distinction here when it comes to estate tax planning? Because of the fact that these individuals cannot exercise any control over the limited partnership, the IRS and through tax court cases have determined that this interest, this ownership interest, has a discount when it comes to valuation purposes. So what does that mean? Let's assume that we looked at all of the assets inside of a limited partnership. Okay, we have some properties. These properties are held in separate LLCs. We have some cash. We have $500,000 in cash sitting inside of there. So the total value of this limited partnership, if you were add it all up, let's say it's valued at $2 million. So for estate tax purposes, right? And I want you to think beyond just federal, think about your state. For estate tax purposes, you might assume that your estate, when you pass on, is worth $2 million from these assets. Well, in reality, when you set up a limited partnership, because you have no control as a limited partner and we're passing on 99% of this interest to our kids, it's not worth $2 million to them, right? It's worth something less. What do we mean by something less? Well, this is where we get into what is referred to as discount valuations. And this is how the wealthy are able to pass on their assets and not pay gobs in estate taxes. What they argue very successfully, we've done this as well here at Anderson, is we have the partnership valued by an appraiser. And the appraiser comes back and they say, well, because of all these restrictions built in that basically tie the limited partner's hands and don't give him any control, this asset, if you were to sell it to somebody with these restrictions, no one's paying you $2 million for it, right? Because there's risks there, right? Because they have to turn over control to someone else. So in order to get someone to buy this, you got to give them a discount, a risk premium. And that can range anywhere from 10 to 30%. Well, that's actually on the high. Let's say 20%. 20%. So in reality, the $2 million in the limited partnership, from a valuation standpoint, let's say taking the 20%, is only 1.6. So this is an important aspect to your overall planning when you're trying to determine what is the best structure for my holding company. If you're concerned about estate taxes, then you want to look at using a limited partnership over a limited liability company for this holding company. Because with an LLC, you do not have access to these steeper discounts because an LLC is different than a limited partnership. In most limited liability companies, even if it's manager managed, the members have some type of control over the company. Whereas in a limited partnership, in the strict sense, the limited partners have zero control. Now, you might be thinking, well, Clint, wait a minute here. I thought you said that the LLC is the one in control, but that's going to be owned by the kids if you pass it on. Absolutely it is. But you separate those out for purposes of looking at the value of the company. You see, the general partner interest here, even if you own that, it's still going to be looked at as a third-party context. And you look at it within its own box, so to speak, and say, hey, what is this worth right here? Don't look at this. It's not relevant. What is this worth? What could I sell my interest for? Because that's what we're looking at when we discount this down. So when you're setting up a family holding company, the way you want to build it, okay, is you want to sit down and figure out, all right, what type of structure do we need for tax purposes? What makes the most sense? Where are we at from an estate tax standpoint? Then what you're going to want to do is you're going to want to talk about control. Who's going to have control over this? Who's going to manage the money? What type of provisions are you going to be putting into your operating agreement to make sure that this company, that whatever it is that you create, let's go back and let's just use the LLC because it's easier to draw a box. Whatever we have here that is owning all of our assets, right? Like this, who's going to step in and control that when something happens? So that gets built into your operating agreement. Now, on top of that, you have to have those charging order protection language inside of this agreement as well, because you want to make sure that, hey, you know, if I get sued while I'm alive, that somebody can't take these assets. But more importantly, when I've passed on, that any creditors of my children or they're going through a divorce, all that's being protected from their potential creditors as well. So that operating agreement is a critical piece of that when you're putting together your structure. So let me just give you a simple example of how this might work, okay? So you get a sense for why the wealthy use this type of structure. So let's say we have two clients, all right? We have this client right down here. We're going to call him John. All right, so John has a portfolio. Let's say he's been investing for 20 years. He owns property in 3 different states. He has a contracting business and he has a brokerage account, right? And so he's got each of these properties, okay, in separate limited liability companies. So he set them up in separate LLCs and they're in different states. And then he has his business over here. Okay, so here's his business right here. And then he has his brokerage account that's in his own name. So here's his trading account right down here. And all of this is owned by John. Now, going forwards, let's say that, all this points back to them. He has a wife and 2 children that he leaves behind. So when John passes away, okay, he has his wife here and 2 kids. How do they assume control of all of these assets? What does that look like? Well, I'll tell you what it looks like. First off, the spouse has to figure out where all this is. And you might be thinking, well, maybe John's been telling his wife the whole time and she's been involved with it. Possibly. In my experience, most of the time, you have one person on the business side in the family that's running the investments and doing the business, and you have the other person in that relationship may not be actively involved in that. So there's a mismatch there. And then when the active person passes away, the survivor is left picking up the pieces and trying to figure out what's going on. Or if both of them pass away, then you have children who are now sniffing around trying to figure out where assets are located. And I've seen this many times with individuals that have come into our office seeking assistance, trying to figure out what their parents own. You see, so this can take a lot of time and a lot of legal fees to piece all this stuff together when you own assets in a disparate manner like this, not to mention probate. And that's why I'm going to show you how to clean this up even further here in just a moment. Now, let's say you have another person. All right, let's say we have Lisa over here. And Lisa was a little bit smarter about her situation. She saw the benefit of this, and so she created that holding company. So here's her LLC. Let's say she did an LLC in Wyoming for its asset protection, of course. And she has similar assets, right? We'll do the exact same asset mix there. Okay, so she has her business, she has her 3 rental LLCs, all owned by this holding company. And let's assume she had $500,000 in her brokerage account, also in that Wyoming LLC. Normally, I would say stick it in a separate one, owned by this, but we'll make it simple. Now, if she were to pass away, okay, her revocable living trust, of course, should own this. As I talked about earlier, we're going to go into that structure. Really, this should be owned by a living trust. All right, that's where you'd want to do it, just like this. Holds all this interest. Now, when she's alive, Lisa is the managing member of this, but she set this entity up here so that when she passes away, her 2 children that are down here will step in to become managers of this limited liability company. So now you don't have anybody trying to scramble around, trying to figure out where assets are located, trying to keep control going of the companies itself, because this company here owns all of these, can actually control them as well as its owner. So you have this continuity of control moving forwards. And the benefit of this structure as well is that if maybe this child here, maybe this child's a dentist and now he's being sued because of something somebody's alleging happened when he extracted a tooth and they've got all this infection going on. Well, if they're suing this child right here, any of the assets inside of this company are going to be protected from their creditors. So you're wrapping up all your assets in this nice little box. Think of it like a present with a bow on it, and you're passing along that one box. Whereas in John's case, what you're doing is you're passing around along chaos. And if you have an estate tax issue and you set this up as a limited partnership, you're also making sure that your beneficiaries have more money in their pocket. Now, let's be honest, okay? You can absolutely mess this up. One of the biggest mistakes I see with these types of structures when people set them up is they think that this is their piggy bank and they just have money flowing in and out of it, and they don't pay attention to the rules on how you need to either move money in or move money out of this type of entity. You see, a holding company offers a lot of benefit, but even though you set it up, you still have to set it up right with the proper type of operating agreement, and you have to treat it with the care and attention it requires, because if you don't, not only do you lose its asset protection, you also lose some of the tax planning that I discussed that could go into it should you be audited. in the future. Okay, so the last thing I would say about these types of structures, I've seen people overly complicated as well from day one. They like to create, 5 different classes of interest, 3 different types of trusts, voting and non-voting units, and waterfall provisions that definitely would confuse any Wall Street analyst, even though the entire portfolio is only 2 rentals and 1 small business. Listen, complexity can be built into this. And so it really depends on where you're at. And the nice thing about building this type of holding company and putting this in place now is it can grow with you. So as the complexity in your investing portfolio, when your life continues to increase, then you can go back and dynamically change this agreement over time. So you don't have to shut anything down. You just redraft a new agreement and restate it. That then will make sure it's in compliant with the complexity that you're facing at that point in time with your overall structure. Hey, a family holding company is the premier entity that the wealthy families use to pass on their assets. If you've got assets and you're looking, hey, how can I set these up the best way to make sure my family's not going to have a ton of headaches and we're going to have the taxes reduced on the estate planning side and make sure that control is consolidated and we're protected, you ought to look at this. And the state that I like to set these up in, I've mentioned it a few times, I always like to set them up in Wyoming. I think that's one of the cleanest, best states to create this type of structure. And if you'd like our assistance in helping explore how this can help you in your individual situation, go into the show notes. I have a free strategy link there. You just click on the link, set up a free strategy session with us. Like I said, 45 minutes, we'll sit down with you. Someone from my firm will look at your situation and we'll show you, hey, based on your assets, how you can structure all this to make sure you can get the benefits that I described in this video. If you like the video, be sure to hit the like button. And I wish you the very best with your investing.